You are on bond for a DWI, and now you've picked up another DWI.
Hold up, another DWI while you're already out on bond for a DWI. That's not just reckless, that's basically flipping the justice system the bird, and we're just getting started, folks. Buckle in.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On October 23rd, 2024, the officer was dispatched to a major one-car vehicle accident in Harris County, Texas. The officer made contact with a witness who observed the motor vehicle had left the scene but was still blocking a moving lane of traffic and had struck a school zone signpost. The officer also observed the defendant's motor vehicle had crashed in the direction moving against the flow of traffic, and the witness identified the defendant as the driver. EMS saw the defendant in the driver's seat of the crashed vehicle with her feet sticking out and the engine still running. Upon contact with the defendant, the officer observed bloodshot eyes, slurred speech, and unsteady balance on the defendant's person, along with a strong odor of an alcoholic beverage, and general disorientation and slow responses. When asked about the accident, the defendant stated she may have fallen asleep but did not remember the crash occurring. The defendant admitted to drinking and consuming Adderall, and she said that she was the sole occupant and operator of the motor vehicle. The officers recovered 2 open...
Let's break this down. Open containers, Adderall, crashing in the wrong direction, and failing sobriety tests across the board. This isn't just bad luck, this is a walking DUI case study. Oh, and that's 286 BAC, that's over 3 times the legal limit. Legally speaking, that's not just impaired, it's dangerous.
Beverage containers from the passenger side floorboard.
Drinking while driving?
Yes, Your Honor. And 4 unopened containers. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 8 out of 8, and 1 leg stand 3 out of 4. A blood warrant was drafted and executed.
And Judge, on the first DWI, the lab results came back as 0.286.
0.026.
0.206, because there's a big difference. Is it 0.26?
Yes, 0.286. Yes, Judge. Yes.
Yes, Your Honor.
Yeah.
That is a very high blood test. Can you run an NCIC? I'd like to know what other kind of criminal history she has, number 1. Number 2, did we have her sign a no driving affidavit on the first one? Because if she did, I'm going to have a contempt hearing.
I don't see a no driving affidavit on the file, Your Honor.
Yeah, well, her driver's license wasn't eligible though on the second DWI.
Probably because of the first and the ALR. Ms. Treadwell, I want you to be perfectly clear about something. I'm going to do everything in my power to protect the citizens of Harris County. Every single day, someone dies because of a DWI in Harris County. And I will do everything in my power to protect my city. And if that means putting you in custody because you repeatedly flaunt our bond conditions, so be it. Now, I'm going to revoke your bond and I'm taking you in. And now, if you do get out, you will have a strict curfew of 7 p.m. to 7 a.m. And I'm forbidding you from going within a car at all. You will now be signing an affidavit, and if I find that you drive, and I don't care what your reason is, I don't care if Jesus comes down and tells you he needs to ride to church, you get into a car and drive, I will have a contempt hearing. Every time you get into a car, it's up to 6 months in jail.
Okay, real talk, this judge isn't playing around. GPS monitor, alcohol sensor, curfew, a bond hike, and a don't even look at a car order. If she so much as thinks about driving, it's contempt. What would you do if you were in her shoes? Or better yet, what should the system do when someone just keeps pushing the limits like this, eh?
Well, fine. On one ankle, you will get a GPS monitor. On your other ankle, you're going to get a scram device, so I know that you're not consuming alcohol. As it stands now, I'm revoking your bonds and I'm putting them both at $25,000. Do you understand? She goes with you. You now have picked up a new case, Mr. Arispe. You now stand charged with terroristic threat or a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officer was dispatched to a residence in response to a family disturbance. The complainant, the defendant's stepmother, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family, if they don't have my money by tonight, I'm going to kill them, as well as I'm going to send my people to shoot them up. The defendant also told the complainant directly, if you don't have my money by tonight, you are going to see. A family member of the defendant and complainant stated that he had seen the defendant walking around with a pistol in his pocket, and the complainant knows that the defendant owned several rifles as well.
This is where it gets real dark. Threatening to shoot your own family over money, that's not just emotionally explosive, it's criminally charged as a terroristic threat, and because he was already out on bond for carrying a weapon, that's a fast track to revoked freedom.
You were on bond for unlawful carrying of a weapon. Did we order him not to have one?
Yes, Judge.
Regardless, you picked up a new case. What happens now is I'm going to revoke your bond in the first place and you will stay with me. I will appoint you a lawyer today, Mr. Ariste, so we can talk about how to go forward, but I am ordering you now not to have any contact with these people. Do you understand?
Sir.
And I'm going to tell you, you pick up a third case, I'm going to go bonkers on the bonds. Do you understand?
Sir.
I'm going to do everything in my power to protect this public at all cost. All right, goes with you. Do you mind appointing him? No. How are you? You know. Who do you want to talk about first?
Let's do the strap.
Okay. Come up, Mr. Lestrap.
So Judge, there was misunderstanding on the case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received the letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
Just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment. Has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
Yeah, stay at home.
Did you come with mom today?
Yes, sir. Stay at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat. How on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens every single time.